Okay, Chapter 7, Part 1. We're still talking about torts. In the last chapter we talked about the torts of negligence and intentional liability and defamation. Now we're moving into strict liability and products liability. Okay, so strict liability and product liability are sometimes linked together and sometimes treated as two torts. The reason that they're linked together is because both of them do not require fault on the part of the defendant. There are no fault types of torts as distinguished from negligence. They're not required to show any negligence or any intent of wrongdoing. Okay, so the history of these two torts. Prior to the Industrial Revolution, we really didn't have a need for a remedy under intentional torts. But as we became an industrialized society and we began buying large amounts of consumer products, people were getting injured by these consumer products. At the time, if you were injured by a consumer product, you could sue the manufacturer, but you had to prove negligence, which was very difficult because it required some expertise, and therefore people were discouraged and did not do so. The government became concerned because when people get injured and they cannot get compensated from the wrongdoing party, they may end up on welfare or some sort of public dole, which is not necessarily good for the government. So state laws were created with strict liability so that you didn't have to prove any negligence on the part of the wrongdoer, the manufacturer in many cases. What this did was it moved the economic risk from the consumer to the manufacturer. And part of the reason behind that was because the manufacturer could compensate themselves for potential losses from lawsuits by charging more for the product. So it's sort of like an insurance. So theoretically, it's supposed to be good for everybody. All right. So this gave way to strict liability, as you see here. I just talked about the rationale. And there's no fault has to be proven. You're responsible for the harm that you cause, either based upon an activity or a product or something similar we'll be talking about. Alright, so one of the types of strict liability is absolute liability. There's basically two categories of absolute liability: animals and dangerous conditions or activities. So animals basically have to do with, let's see if we have a slide on it. Yeah, we divide animals into wild and domestic animals. So a wild animal would be one that's in the state of nature, would be something like a lion or a bear. If you keep a lion or a bear and they injure somebody or somebody's property, you're absolutely liable. That person does not have to prove that your fence was too low or that the rope that you tied the animal to was negligently tied. No, all they have to do is prove that they were injured and that it was a wild animal. For domestic animals, it's a little bit different. For domestic animals, generally there are two rules. If it's a domestic animal, well, not two rules, but two ways of looking at it. If it's a domestic animal and the animal has never shown a propensity towards danger or towards injuring somebody, then the injured person has to show that, and if they can't, then they cannot win. On the other hand, if the animal has previously shown some propensity towards doing harm, then you're absolutely liable. So if your dog has bitten somebody before and now bites your next door neighbor doesn't have to prove any negligence on your part. Okay. In addition to that, a number of jurisdictions across the country have labeled certain breeds as being having a propensity to do harm, and therefore All you have to do is show that it's that breed and nothing more, and if that breed harms somebody or some property, then you're liable regardless of whether or not you were negligent. Okay, and this is pretty much the way the law is today. It used to be that we said that dogs had every dog deserves one bite, and what that meant was that unless your dog had bit somebody before, you weren't going to be liable. But now we look at the rule that I just stated, which is the propensity to harm somebody. It doesn't require a bite. If your dog has lunged at people before or done something that would indicate to a reasonable person that your dog has a propensity for doing injury, then even though it's a domestic animal, that's the rule that applies. So we looked at that, and here's the rule there. And I just covered that. Okay, abnormally dangerous activities. These are things that are activities that are inherently dangerous. What that means is that no matter what the person does that is conducting that activity, it's still a dangerous activity and can cause harm. The typical example that's used in almost every lecture or explanation is blasting. Okay, so sometimes we use blasting, like dynamite, to bring down an old building. If you do that and somebody's injured or an adjacent building suffers window damage or other structural damage, then you're going to be liable, and the person doesn't have to prove any negligence. You may have put that dynamite exactly where it was supposed to be according to the book. You did everything 100%. Doesn't matter. It's absolute liability because it's a dangerous activity. So an example is blasting. The elements of this are existence of an abnormally dangerous condition or activity, knowledge of the condition or activity, damages, and causation. Okay, now, how does a court determine whether something is a abnormally dangerous activity? These are the criteria that the court looks at. No one criteria is more important than another. They just weigh all of these criteria. Is there a high degree of risk of harm to persons or property? Is any harm that results from the activity likely to be serious? Can the risk of harm be eliminated by exercising reasonable care? Is the activity a matter of common usage? Is the activity inappropriate in reference to the place where it is carried on? Is the value of the activity to the community outweighed by its dangerousness? Okay, so here are examples of things that the courts have found to be abnormally dangerous: crop dusting, poisonous gases, etc. Here's some of the things that are not considered abnormally dangerous: an airline crash, an irrigation dam, or a falling tree. Okay, so your magic word for Chapter 7 is absolute. We'll pick up with the next video with products liability.